Right, we'll get going. So welcome and good morning, everyone who is joining us today. My name's Alex Bedford. I'm the Customer and Partnerships Manager at Zurich Municipal. And I'm really delighted today to welcome you to this webinar in conjunction with Zurich Resilience Solutions, our risk management partner within Zurich, and with our claims team, so Stephen from our claims team, to talk about safeguarding and abuse risks in local government. So a cheery topic for a Friday morning, but actually so important, and one that is constantly evolving and changing. And I hope we're going to bring a really nice dynamic to the discussion using our claims insight and also our risks trends insight with the experts that are joining us from across the business. We will be recording this session and you will be sent a link to the session afterwards. It will be hosted on our YouTube channel so that you can watch it back, or you can share it with any interested colleagues. We won't be sharing the slides, we'll just share the recording because with safeguarding, context is everything. So it's really important that you have the conversation as well as the slides if you want to go back to this after the event. So I'm joined today by Stephen McGee, our Head of Specialist Claims, Large and Complex Claims, and Alex Cunningham, our Safeguarding Risk Consultant from Zurich Resilience Solutions. I'm going to hand to Stephen first. Stephen actually has come in on his day off to do this. So he's here for half an hour. He's going to talk through the claims trends that we're seeing at the moment, but please do pose any questions you have for Stephen in the chat. We will have some time before he has to dial off to cover those. And we'll address any others sort of after the event. But don't wait till the end. Please pose questions for Stephen as he's going. With that, I will hand over and thank you.
Thank you, Alex. Yeah, so I'm Stephen McGee. I head of Zurich Specialist Claims Team. Worked in Zurich for 17 years in a variety of claims roles, and I've been involved in the Specialist Claims Team for just over 10 years now, and I've managed it for 6 years. So got quite a lot of experience in this area. Looking through the attendee list, I noticed a good number of familiar names that I've dealt with over the years on claims of this nature. So I'm pretty sure you all know the ins and outs of this anyway, but just wanted to give a very whistle-stop tour of the sort of latest developments and what's going on, what's potentially coming down the track. So let me just see. So here we go. So this is the only slide you'll be glad to hear. I'll probably be speaking for about 15 to 20 minutes, and then, as Alex said, we can hand over and take any questions that you've got. If there is any questions that come up, maybe when we go into the second part of the presentation that Alex Cunningham's running, then just pop them in the chat and I will come back to them next week, and I'll pick up the answers over Teams or via email. So safeguarding abuse is something which I've presented to customers on a number of occasions over the years. The reasons for the uptick in volume over the last 10 years or so are multifactorial, but as I've put to the left-hand side of this slide here, a few graphics, which will be familiar to most of you. In many respects, things changed completely in the UK following the death of Jimmy Savile, who was a prominent household name during the 70s and 80s. He passed away in 2011, and in 2012, a scandal broke where it emerged that over the course of 5 decades, he had used his position as a celebrity with friends in positions of high authority, like the Prime Minister and things like that, to commit abuse on hundreds of vulnerable individuals. It was pretty much hiding in plain sight. That scandal lit the torch paper for a series of scandals in a variety of different areas. Barry Bennell was also pictured here. He was the prominent youth coach who was associated with Crewe Alexandria and Manchester City football clubs during his career, and again used his position of authority to commit sexual assaults on multiple boys who were aspiring football players. We then had, roughly the same time, the child sexual exploitation scandal, which uncovered the grooming of young girls by criminal gangs across several towns in the UK. And this particular topic has actually returned to prominence in recent times, following some political wrangles at the start of this year. And it's also been the subject of a recent Channel 4 documentary, which has been amplified on social media at the moment under the hashtag #TheyKnew. A lot of this led to the government initiating an independent inquiry into child sexual abuse, or ICSA as it's referred to, which ran from 2015 to 2022. and this led to a number of recommendations, some of which the government are going to take forward in due course, and I'll get onto that shortly. So all of this, all of the increased publicity and attention on it really led to a surge in claim volumes. My team, for example, sort of doubled in size due to the increased notifications that we were receiving, and it really became a major area of focus at Zurich and with CEDEM in particular. So it was with matters now very much in the public domain and survivors speaking very openly about things. Part of the stigma had been removed for victims, and it led to more basically being prepared to come forward. And alongside this, the law had been developing at quite a rapid pace, and I'll come on to that towards the end of my presentation, but it basically made, in certain settings, claims a lot more easier to succeed on. In more recent years, the volume of claims has begun to subside and probably plateau, but the volumes are still pretty sizable. And as Alex and I will discuss, it should still remain a major area of focus for our customer base, and obviously as it remains a major priority for Zurich as well. So just looking at regulatory reform, first of all, I mentioned ICSA a few moments ago and wanted to touch upon some of the recommendations which the government made announcements on recently. The main change, the one that got the most attention, is that they plan to remove the 3-year limitation period for child sexual abuse claims. So at present, a claimant has 3 years from the date of incident to bring any personal injury claim. Clearly, in the case of abuse claims, a lot of these claims are brought out of time. But where that happens, the claimants will ask the court to exercise their discretion under Section 33 of the Limitation Act 1980. And there are several factors for a court to consider in that regard, but it really boils down to whether the defendant has been prejudiced by the delay or not, and whether a fair trial can still take place. Even with the removal of the 3-year timescale, the legislation which is to be enacted will retain the defendant's right to a fair trial remains, basically. However, the burden of proof will be reversed. So at the moment, on a claim, it's for the claimant to convince a court that there is insufficient prejudice on the part of the defendant, and that a fair trial can still take place, i.e. witnesses are still about, documentation exists, the survivor may have a criminal conviction against the abuser, etc., etc. However, under the new legislation, it will be for the defendant to prove that a fair trial can still cannot take place if they want to rely upon limitation defence. Practically speaking, from a Zurich perspective, we don't really see that changing how we will deal with claims. Our philosophy has always been not to use limitation as a tactical or a technical defence, and we'd only deploy it in situations where we genuinely thought that a fair trial could not take place. Obviously, when you're dealing with claims of this nature, highly sensitive, there are moral and ethical considerations to sort of put into the mix, more so than there would be maybe on like a standard personal injury claim where somebody's tripped over a pothole in the highway or whatever. We saw limitation removed in Scotland and the Scottish jurisdiction in 2017. Whilst the legislation between the jurisdictions will have some slight differences, we're already cited on the approach that the courts are likely to take. There have been a couple of cases in Scotland where the claim has still ultimately failed on the grounds that a fair trial could not take place, even though on the face of it, limitation has supposed to have been removed. But the legislation needs to retain safeguards within it so that it doesn't fall foul of the European Convention on Human Rights, basically around defendants' peaceful enjoyment of property or their funds. The above said, it is very possible that the removal of limitation will lead to an uptick in claim volumes, and it's inevitable that new solicitors will come into the market and try their hand at it. So we should be prepared for, I guess, a surge in claim volumes over the next couple of years, and perhaps claimants having another go at claims that have previously failed in the past. The law of apologies is also to be reformed in due course. In the past, there has been a reluctance on the part of some organisations to apologise for wrongdoings on the basis that it may prejudice their insurance cover. Zurich, I should say, have never taken that position, but other insurers may well do so. As I will explain shortly, the law in respect of vicarious liability is strict, so an apology in the context of such a matter may be construed as an admission of liability. The government will be looking to enact legislation that makes it clear that that is not the case. The viewpoint on this is that the use of apologies is a genuinely helpful way of bringing debates and disputes to a conclusion, sometimes alongside obviously settlements and things like that. Next, redress. Another one of the ICSA recommendations was that the introduction of a national redress scheme. Like the other recommendations, this was made in late 2022, but it was essentially kicked into the long grass by the former Conservative government, who at the time were being led by Liz Truss, and we all probably remember there was a lot of stuff going on back then, so you can understand why this sort of fell down the list of priorities for the government at that point in time. It was only really brought back into the public realm again at the start of this year when Elon Musk caused a bit of a social media stir. And a lot of people would have predicted that this would not have been taken forward due to concerns over cost, and that has ultimately proven to be the case, as the Labour government have recently announced. They've had a fair bit of adverse publicity around this, but from an economic perspective, it is perhaps understandable. Redress schemes have been set up on a similar basis in Scotland and Northern Ireland in recent years. The estimated cost of the Northern Irish scheme is thought to be close to £100 million. And at the start of the Scottish scheme, it was predicted that the overall cost would be somewhere in the region of £500 million. So if you use the Scottish figure and work that forward on a proportionate basis, with Scotland making up 10% of the UK population, you could see the English and Welsh equivalent getting close to, if not higher than £5 billion. And the reality is that sort of money just doesn't exist in the Treasury at the moment. So that has been scrapped for the time being, at least anyway. Another quick thing to mention is that one of the earlier ICSA recommendations, going back to 2019, I think, was the introduction of a specific award for general damages relating to sexual and physical abuse. This was brought in 2022 within the 16th edition of the Judicial College Guidelines, and increased considerably in the 17th edition, which was released in 2023, with the award for a severe case involving abuse increasing from £45,000 to £120,000 as the range for that type of case, to £110,000 to £183,000. So the obvious impact of this is that settlement awards are now increasing. Claimant solicitors are looking for significantly higher damages when we do get to the point of settling cases. But that is, I guess, largely consistent across all areas of personal injury at the moment, as you're no doubt aware. Final section is legal reform. So one of the reasons for the drop-off in claims in recent times has been the impact of the law on a specific category of abuse, which is referred to as failure to remove, and a lot of you on the call will be familiar with this type of case. There has been a run of highly important cases over the past 7 or 8 years, and I have on the slide here 2 Supreme Court decisions which Zurich supported their customers on. These cases ultimately led to the harmonisation of the law in respect of public authorities across all areas of responsibility, to include social services liability, which has previously been subject to an exception. The basic legal premise is that a public authority has a duty to do no harm, and what that essentially means is that a public authority, so a council, a police service, a fire service, does not owe a duty of care to the public at large for harm caused by third parties, but it does have a duty not to make matters worse. The reason that the law is as it is because that if a private individual would not be held liable in negligence, then a public authority cannot be held liable either. The same rules apply to everyone. So like you and me, a public authority does not owe a duty of care to stop the man in the street from being murdered, or the building across the road from you from burning down. The principle now applies to failure to remove claims, which generally involve a child who's been abused or neglected within their own family home, with the allegation being that a social services professional should have taken steps to remove the child from the home and bring the harm to an end. Before the CN decision, the claims were subject to the usual tests of negligence, and we'd assess claims on the basis of the famous Bolam test, which in this situation meant that if a group of competent and experienced social workers would have acted differently, then liability would arise. CN confirmed that liability would not arise in such situations, and any doubt that remained was swept away in HXA, where it was made crystal clear that no legal duty of care arises to stop a child from being harmed by its own parents. Now, this is a concept that is difficult to explain and square in certain situations. However, when dealing with the law, and that of public authorities in particular, we do need to be careful to distinguish between a duty of care, which is perhaps better characterised as a social obligation, and true legal duties of care which are enforceable by claims for damages. In short, of course, a social services department has a duty to do their best for the children that they have oversight of, but the mere performance of their role does not necessarily give rise to a true legal duty. There are some limited exceptions to this, however, which in the interest of time I'll not get into, but I will just briefly mention one, which is an area that is currently subject to further development at the moment. That is the Human Rights Act, and Article 3 under the Human Rights Act in particular, which deals with the prohibition of torture, inhumane and degrading treatment, which is an allegation that has now been levelled on a lot of claims, new claims and claims that have been reformulated after the recent Supreme Court decisions. The first case to test this was heard by the Court of Appeal in 2013 in the case of AB versus Birmingham City Council and Worcestershire Council. That's another case that Zurich were involved in. The legal considerations under the HRA are highly complex, but the main points to satisfy are that the defendant must be on notice of real and immediate danger, and the threshold of seriousness needs to be met. So it needs to be a very serious case to sort of hit the threshold. The AB case failed on the threshold point because in that case the claimant was subject to low-level neglect. Now it's still a horrible case, but in the grand spectrum of what we see, it was at the sort of far end of the spectrum, if you know what I mean. If it was physical or sexual abuse, then the threshold would have been met. So the threshold will be met on a lot of claims, and our assessment of a lot of claims that we are dealing with just now is that the threshold will be met. But the real battleground under the HRA will be what is meant by being on notice of real and immediate harm. The advice we've received thus far is that the warning signs of danger require to be pretty obvious to social workers, and as a result, the number of cases which will succeed will probably be very limited. However, it's an area we're tracking very carefully. We need to be very wary of picking the right cases to test the law on, because we could end up with a very, very unfavourable judgment if we're not careful. So yeah, there is likely to be further test litigation in this area in the years to come, and I suspect Zurich will probably be at the forefront of that. Final topic is vicarious liability. Now again, this is another very complex and confusing legal doctrine, which there has been a lot of litigation on over the past decade or so, and it's really confused even the smartest minds in the legal profession. But from a claims perspective, it really is the main risk, and this is the area where most of our claims are coming from at the moment. So the basic principle of vicarious liability is that an employer is liable for the wrongful acts of its employees. The liability is strict, so there is no need to establish negligence or fault on the part of the employer. For it to arise, there is a two-stage test, and the two limbs of that test have been subject to a long line of authorities, considering when they apply, and I'll go through a couple of them in a minute. The first element considers the relationship between the employer and the employee, and as I'll discuss shortly, we're now not always talking about conventional employment relationships. The second element is whether the wrongful act of the employee was within the scope of that relationship. So that second limb was subject to a very groundbreaking case of Lister versus Hesley Hall back in 2001. Before that, the law provided that an employer would only be vicariously liable where the tort committed related to what the employee was authorised to do. In Lister, it involved a warden within a children's home who abused children who he was employed to care for. Abusing them was plainly not part of his roles and responsibilities, so the claim was defended by the defendant up until the point at which it reached the House of Lords, and they changed the law basically in this area. Landmark case, and they replaced the concept of the authorised act with the close connection test, and they said that the employer had put the warden in a position where the close contact that he was given to children through the work created a sufficient connection and a special risk between the acts that he committed and what he was employed to do. So that really changed the landscape. The key principle coming out of this decision was that if the acts, criminal or otherwise, are closely connected with the person's employment, then the employer will be vicariously liable. About a decade after Lister, in a couple of claims against religious bodies, the courts extended the scope of vicarious liability to non-employment situations, holding that it was sufficient to show that the relationship between the defendant and the wrongdoer is one that is akin to employment. so like an employment situation, but where there is perhaps no contract of employment or payment of wages. And that scenario arose in the ZM space in the case of Armes versus Nottinghamshire County Council from 2017, where the local authority was held liable for abuse perpetrated by foster carers who the local authority had placed the claimant with. It was a relief for the defendant community when the development of the law, which was very much moving towards a sort of strict liability, like a no-fault liability position, it came to a bit of an end in the case of various claimants versus Barclays Bank, where it was held that liability would not arise where the tortfeasor, that being the wrongdoer, was a genuine independent contractor. And I know that was a major concern for ZM customers, and that when they were subcontracting, set some of their roles and responsibilities to outside parties as to whether, in the case of where those organisations maybe went bankrupt and things like that, whether the liability would come back to the local authority on a vicarious liability basis. But the law in Barclays clarified that where the acts are committed by a true independent contractor, then liability will not arise. And in the ZM context, again, a similar decision was reached in the case of SKX versus Manchester City Council, which is a case where the claimant was placed at the notorious Bryn Allen Children's Home in North Wales, and in that care home suffered abuse, but the claim against the local authority that placed the child in Bryn Allen failed on the basis that that Bryn Allen was essentially acting as an independent contractor, so liability did not devolve back to the placing authority. In terms of the stage 2 test, again, going back to Lister, the law in that regard was stretched out by a case involving Morrison's supermarkets in 2016, but was brought back into line again, coincidentally, by another case involving Morrison's in 2020. And I'll not go through the details of those cases because a lot of you are probably familiar with them. But the position basically remains and goes back to the position that was sort of set down in Lister, in that there needs to be a sufficiently close connection between the acts committed and the wrongdoer's employment. This has been clarified and confirmed by the appellate courts in a couple of recent cases, first one being BXB versus Watchtower Bible. It was a claim brought against the Jehovah's Witnesses for an act committed by an elder, on the basis that the employment with the Jehovah's Witnesses, or the quasi-employment, or the situation which is akin to employment, led to the relationship with the survivor developing, but the actual abuse itself happened in a private setting, so that did not go back to the liability did not go back to the defendant on that basis. And again, another sort of ZM type case, the case of MXX versus a secondary school from 2023. The Court of Appeal considered a case where a Year 8 school pupil was assaulted by an 18-year-old work experience student who spent 1 week at the school. The stage 1 test was satisfied on the basis that the school had a degree of control over him, but the claim failed on the stage 2 test on the basis that the wrongdoing occurred many weeks after the relationship with the school had ceased. The relationship merely provided an opportunity for the two to meet, but it was not sufficient to cross the stage 2 threshold because the abuse occurred outside the sort of school premises, and there was a good number of weeks of sort of removal from when he was at the school. So the law on vicarious liability now appears to be in a relatively settled position for now at least, but I guess the main point to bring out is that if an employee commits a negligent or criminal act that can be closely connected to their duties of employment, then liability will attach. And as I said, this is where we're seeing the real volume of abuse claims these days, and probably will do for the foreseeable future. And this is where I lead over to Alex, who will talk about what can be done to protect against that sort of risk. So I think we're stopping for me to take any questions that anyone might have just now.
Yeah, thank you, Stephen. So I know it always takes a little while for people to type their questions. I'm just gonna kick off with a bit of a general one because we can't say it enough. So we'll have a lot of risk and insurance leads on this call and watching back. In terms of working with their organisations on these risk areas, preparedness, trying to stop these claims occurring in the first place, but also being prepared to defend these claims as and when they come through. If you've got any tips for what insurance and risk managers should be doing with their organisations to get themselves in the best possible position?
I guess probably one of the obvious points is have a detailed record of your insurance history. And I know from dealing with a lot of the people on the call just now that most local authorities do have that sort of nailed down, but just moving forward, just keeping a really strong record of that I guess will be sustainable for the decades to come, because with limitation being removed, we could be dealing with claims in 30, 40, 50 years time arising from events that are occurring now. And there will always be a need to deal with those claims. So keeping your documentation. From a vicarious liability perspective, I guess it comes down, and I think Alex is going to talk a bit about this, but it's in terms of your very, very careful disclosure checks when you're bringing in employees, particularly employees that are going to be working with vulnerable service users and children and things like that. Ultimately, as we've seen on the claims side, even if you do have a really robust sort of employment check system and stuff like that, there is still the odd one that will slip through the net. It's just unfortunately a grim part of society that these types of people are about, and they find ways to get into employment positions where they've got access to vulnerable people. So that isn't completely avoidable, but there is definitely things that you can do, and it's just keeping a record. I guess this applies to any type of claim, but keeping your documentation around employment checks and risk assessments and all that sort of stuff.
Fab, thank you. So we haven't had any questions in, and I know you do need to dial off. So Stephen has said that if questions occur to you sort of as we go through the rest of the webinar, please do put them in, and we will come back to you on them after the event once Stephen's back. So yeah, unless this is always the place where someone puts in a question right at the very last minute. But I can't see anything coming through, so we'll let you get off, Stephen. Thank you very much for joining us.
Thank you.
And yeah, have a great rest of the day. And I will hand over to Alex Cunningham now. Thank you, Stephen.
Thank you.
Great. Thank you so much, Stephen, for that. I just to give a little bit of an introduction to myself. So I am Safeguarding Risk Consultant for Zurich Resilience Solutions, and I work primarily with Zurich municipal customers and colleagues, underwriters, and other colleagues across Zurich Municipal are working on a whole range of safeguarding issues. Obviously a huge topic, and there's only one of me. So what we're going to kind of cover today is a whole variety of different areas across kind of public sector and kind of a variety of different risks that are coming into play. But the kind of work that I do kind of day to day is across all the different segments that ZM operate in. My background is more in children's services, so I was a statutory children's social worker right up until starting in post with Zurich. Prior to that, I'd worked in London and in Scotland in a variety of different local authorities, and I've also, prior to becoming a social worker, I'd worked in various different charities and in the UK and overseas. So kind of a little bit kind of to talk a little bit about my background kind of coming into this role. We're going to I'm going to talk a little bit about, we're going to kind of cover off the kind of current landscape, some of the kind of key risks across a variety of different areas, children's social care, education, as well as adult social care, and then think a little bit about some future trends. And I'd really encourage you, if there's kind of questions you've got, but also kind of discussion points, kind of whilst I'm talking, that are kind of triggering ideas or things that you'd like to discuss and have a little bit of a backwards and forth about, please put those questions in or kind of put those points in, because I think it's about kind of what we're really keen to do with ZRS and ZM is to improve our collaboration with customers, particularly around this area, because it's an ongoing risk and it's a growing risk in particular areas. And as Stephen kind of pointed out, the legal landscape, the claims landscape is shifting. But so is the wider kind of policy, kind of social care landscape that local authorities are consistently managing, as you know, only too well. I'm going to start with a question, which my colleague is going to very helpfully pop up a poll to help us with. So I'm really keen to hear from you about what the main challenges are that come to mind, thinking about your local authority, about what your kind of main risks are around children, adult social care or education, so kind of any of those kind of three areas. So if you should hopefully see a poll that's appeared, and if you're able to just pop in some answers, that would be really helpful, and it will formulate a lovely word cloud as well. And what I'm then going to speak to is hopefully lots of the responses that you're putting in are things that I've already, I'm going to then go on to speak to in a second, but it's just really helpful for me to kind of see where you're at and kind of what your main concerns are. We'll give you a minute to do that. Oh, great, we've already got a response. Great. Great. Okay. Fabulous. Really, really getting going now. You could just please keep putting responses in. I'm going to jump onto the next slide and start speaking through some of these things that are coming up, but it's really, really good to see. So please keep adding to it. And I can see already that a number of the areas that you've highlighted are things I'm about to speak to. Things like lack of placements, kind of staffing, budgets, absolutely, staff retention, as well as kind of resource and kind of recruitment. And yeah, really interesting as well around kind of loss of records as well. So kind of thinking through some of the kind of key challenges, particularly in children's social care. There's so many that we could speak to, and I've picked out a few kind of highlighted kind of ones that are particularly being talked about kind of in the sector at the moment, and kind of consistent, feels like the kind of consistent challenges. I've also spent some time doing a bit of a spot check of risk registers in lots of our local authority customers, and these are kind of some of the big themes in children's social care, education and adult social care that I'll go on to speak to as well. So I think I'll start with, because it's come up in the word cloud, commissioning placements for children with complex needs. It's a huge challenge, a huge area that local authorities are dealing with. I myself, as a practicing social worker, very much experienced that when I had a child that I was needing to place, potentially in an emergency situation or in a planned situation. The day-to-day challenges of finding an applicable placement, something that met the child's needs, that was available at the right time, with the right carers, and with the right skills, was an ongoing difficulty. And the reality of that is that impacts the social work support that can be provided to that family, because unfortunately at some points social workers are unable to find appropriate placements, and difficult decisions need to be made about how things are going to be managed to make sure that the child and the family are safe and the right decisions are being made. So the big picture on this is, the huge costs and kind of availabilities associated. There's big concerns about profit making in the sector, the impacts of that on local authority budgets. There's a kind of tightening inspection regime from Ofsted, obviously kind of looking at unregulated placements in particular, which have been something that local authorities have been forced into position to use because of the lack of available registered placements. And there's been, relatively kind of recent changes in the last kind of couple of years around that to make that safer for children, but obviously the challenges for the local authorities for you still remain. There's there are moves, and there's kind of national government moves, and there's local authority moves to work on this continually. But it's such a massive challenge that it's really about a whole variety of different possible solutions that need to kind of come together. The other area is around secure care capacity issues. And the kind of the numbers of secure care provision that there is, the number of beds that are available, the use of those facilities, England and Scotland as well. So sometimes children, again, I know this as a practicing social worker and having worked in some children's homes, children from England being sent to Scotland because of a lack of capacity in England, which is a really challenging position for children, their families, and puts additional pressure as well on social work teams to be able to adequately support those children in those placements with the big distances. In Scotland, there's been a reduction in the number of secure care provision. Edinburgh Council closed theirs recently, so there's four services for the whole of Scotland now. So the rates, and also there's just been some recent statistics published by the government about the numbers of children in secure care. So there's been an increase of that from the previous year. This is alongside the increasing numbers of children on deprivation of liberty orders, which again is a significant issue in children's social care. The use of deprivation of liberty orders to particularly place children in unregistered settings has grown astronomically. The huge numbers of kind of applications. In 2024, there were, for secure orders, there was applications for 224 children in England and Wales, but for dolls it was 1,200. So the whole area of placing children with additional needs or complex needs, behavioural needs, experiences of trauma, extrafamilial harms, so harms outside of the home, things that are going on in communities, and the challenges of keeping those children safe whilst also managing the resourcing and the huge budget pressures that this kind of results in for the local authorities is a real kind of area that we're very aware of at Zurich. SEND pressures, I'm going to talk about a little bit in the next slide. I've put it in here because it's very relevant to children's social care, but also very relevant to education as well. The kind of continual process for local authorities and just keeping up to speed with social care reforms. It's obviously such a political topic, and there's a lot of attention being paid to what the right reforms are, what the right approaches are, what the right technical solutions are to some really complex challenges and problems with with children's safety, with adult safety, and that's something that I can see regularly in risk registers as well, thinking about how those changes are being kept up to date with and implemented. Something I kind of wanted to talk a little bit about as well, which I don't think has come up in the word cloud, but kind of feels like a little bit of a backbone to a lot of kind of what I'm talking about, both within children's social care, adult social care and education, is early help. And the differences over time of the kind of the focus on early help, and then the kind of shifts in kind of political thinking, and then how that's, and the funding associated with that, and then the impact that that's having on day-to-day teams trying to support people in their roles. The UN Convention on the Rights of the Child talks about proactive prevention, but there isn't any legislation to provide preventative services for children. So local authorities are sometimes pushed to move away from early help services and focus on the more acute services, the child protection, the kind of court arena, kind of children in care. And obviously if there's a lack of that early help to support and act in a preventative way to support families at an earlier stage, then we've got more families, more children potentially coming into care, or certainly being kind of having social work intervention within their lives. and the pressures are seen across the system, within schools, within health, as we can see in a lot of the different kind of areas that are causing challenges for our customers. In terms of kind of just thinking about kind of funding as well, particularly around early help, but in general, overall funding for local authority children and young people services has fallen by an estimated 2 billion between 2010 and 2018, representing a 23% reduction. There's huge budget pressures, and the funding is simply sometimes not there in different local authorities. There's also the issue of postcode lottery for children and families, of different local authorities having different services available, but if you're in a different local authority or neighbouring local authority, not having access to those. Also the kind of wider context of increasing child poverty in England. Rates of child poverty are starting to fall in Scotland because of some different legislative actions there, but the rates are high in both countries. I think it's around about 30% in England, and around about 23%, I think, in Scotland. So huge numbers of children are living in poverty, and the families that children's services staff are working with are working in a context where poverty is a daily challenge and a daily struggle for them, with the reduction in early help services, and all the various other kind of challenges within the system. It's really a system that is struggling. And then kind of the last part I just want to kind of touch on here before I move on to the other areas is about, I mentioned it kind of earlier, about kind of complex caseloads and volume pressures. This is something I'm particularly kind of interested in. When Stephen was talking about claims areas, I think one of the big areas that we're thinking about is the multiple challenges in the system, and the resulting impacts on day-to-day practice, kind of business as usual, kind of social work teams, getting on with the day-to-day job of supporting children and vulnerable people, but the realities of the complexity of some of the social issues that they're dealing with, as well as the volume of referrals that are coming in, the kind of children within the system, and how they're managing those, and some of the risks that are accumulating because of that have then the potential for claims, if we were thinking about something around vicarious liability, for example. And some of the kind of areas around that we're seeing around trends, about kind of the complexity of caseloads and kind of volume pressures, things around extrafamilial harms outside the home. That's a clear growing need within social work. Social work used to be more focusing within the family, but is really the extrafamilial harms, harms within communities, criminal exploitation, child sexual exploitation are areas that are growing, and is kind of, but there's corresponding kind of growing responses by local authorities and some really amazing innovative projects and work that's going on, but it's just acknowledged that kind of exists. And then families facing multiple challenges, so potentially poverty alongside domestic abuse, with other factors, parental mental health, child mental health. That's a kind of area as well. And kind of child mental health in general is becoming an increasing kind of challenge, which very much links in with the next part that I'm going to speak to, which is around kind of some of the key challenges in education and student mental health we're seeing as a key area. The challenges with extremely long CAMHS waiting lists, or when children are being seen, potentially not receiving the support that they feel is working effectively for them. School absence rates are still higher than before the pandemic, and particularly vulnerable children, so children with additional needs, children who are kind of within the SEND kind of system, children that have also abuse or neglect at home as well, are children that are maybe not being seen quite as regularly at school, or are completely not attending. And then there's also the behavioural challenges that schools are dealing with and kind of managing with some of the children that are attending, as well as their kind kind of general kind of presentations and their ability to learn and their kind of engagement with learning when other things are going on for them in the rest of their lives. Send pressures is a huge area. We've got lots of increasing needs in children, lots more identified needs in children. And again, there would be an argument that some of that is linked to the impacts of post-pandemic and post-COVID. And the support that's available is under a lot of pressure, both from funding, but also staffing, recruitment levels, getting the right staff in the right roles, and retaining them is proving a kind of ongoing challenge. And there's then potential impacts around children not being receiving the education that they need. So the potential for claims around failure to educate as well is something that we're conscious of. Social media harms as well. I think this will be something that people will be kind of very well aware of. So I probably don't need to speak to that too extensively, but we're very conscious at Zurich that that there's it's a growing threat and challenge for individual schools to be managing. It's a growing landscape that didn't previously used to exist in the same way, but is something that is taking up. It's requiring a lot of support and a lot of kind of intervention around. And then kind of last area, before we kind of talk about potentially kind of future trends, is around the key challenges in adult social care. Again, a system that is under kind of a lot of pressure, budget pressures. There's a number of attempts of reform, and the Casey Commission, which was announced in January this year, we'll be looking at implementing a national care service with that report due next year, and there will be kind of changes coming, and there are also some changes already with the care quality kind of assurance framework coming into place, which again I've seen on a number of risk registers and local authorities, so I know that that's being worked on and kind of geared up for. The adult social care kind of provider market is complex, as it is within children's social care as well, in children's homes. And recent kind of government announcements around employer national insurance contributions will have a knock-on effect there. But I think one of the kind of big areas that this quote kind of demonstrates at the end of my slide here is about kind of some of those knock-on effects. The three areas I've discussed today: children's social care, education, and adult social care. Given the scope, given the statutory responsibilities that these three areas kind of cover in local authorities, they account for a huge amount of staffing and a huge amount of cost for local authorities. And kind of when the systems are not working as effectively as they could, or there's kind of increasing costs in particular areas, that has a knock-on effect onto other parts of local authority services, as you know very well, and we're very kind of aware of in Zurich as well, to think about the wider context of these kind of specific areas and the potential for claims linked to these areas, but also what that's doing for the local authority and the challenges that you are dealing with on a daily basis, and the trends that we're seeing kind of over time as policy shifts, and as some of the risks and challenges are shifting over time. And then just to kind of finish up, just thinking ahead to some of the kind of future trends, I would kind of start this by saying that, especially after having listened to Stephen, I think you can see that a number of one of the big areas we really are more concerned about is, I guess, some of the day-to-day kind of business that may result in claims, and we're very conscious of that being a kind of ongoing kind of risk. And one of the things that I'm very conscious of is some of the big changes that are happening in the sector, such as local government reorganisation in England, and the kind of knock-on effects that has to to pressurise local authorities already, and what the changes will look like, what they will mean for local authorities, what the impacts will be on these individual kind of departments, but also the kind of wider structure, and then thinking about how that might knock on around the kind of day-to-day work, and then subsequent potential for claims, etc. I think that there's some interesting things happening within, aside from kind of local government reorganisation, there's also some changes that have come in from some children's services reviews in England around regional adoption agencies. So thinking about kind of different approaches to engage with families to support adoption processes. There's some really interesting and innovative pilots and pathway projects that the government is funding, both in Scotland and in England. The Promise in Scotland, the Care and the Care Review in England have led some really interesting approaches, and those things are still running and are kind of trickling through, which I think will produce some really interesting approaches that can be embedded. But things it takes a long time for the system to catch up. Just to kind of mention, which may be something that your local authority is thinking about and kind of already thinking about plans around, agency and international staff changes, the immigration white paper, which was announced in the last couple of weeks from the government, will be stopping international recruitment for care workers, which is going to have a really significant impact on the care sector. And I think we're yet to kind of fully understand what that will look like. But there has been a huge increase in international recruitment in the care sector from 15,000 in 2020 to over 100,000 in 2023. So it's been an area that's been really supporting international recruitment. Has really been supporting the UK care sector, and the changes are going to be quite profound, I think. There's also agency social worker reforms, which are coming in, pay caps on locum hourly rates and various other kind of restrictions in order to kind of manage that market, which will have differing kind of impacts for different local authorities, and are welcomed, and also sometimes not welcomed by different people in different areas of the sector. And I just wanted to touch on a couple of things. Stephen had mentioned about the They Knew campaign, which is quite a recent campaign, just come up in the last kind of, I believe, month or so. Again, looking at kind of child sexual abuse and exploitation, thinking about kind of looking at cases, older cases, kind of historic cases, and looking at kind of involvement from local authorities and police, etc. So the kind of child sexual exploitation kind of concerns and are still there, and I think we'll keep an eye to kind of see how that kind of moves forward. And then just very, very briefly, just to finish up as well, the mandatory reporting of child abuse in England, I'm sure you're aware, but the scope has been reduced from the initial ICSA recommendations. There was some very strong recommendations from ICSA around kind of making that potentially criminal for professionals not to report suspected signs of child abuse and child sexual abuse. This has been adjusted, and it's been reduced. So there will be a duty, but it won't be criminal, and it won't be extended to indicators. So it strengthens it kind of strengthens the requirement for professionals to act, but it isn't to the level of kind of criminality or extended to indicators, because the complexity of that was understandably kind of very difficult to work with, and was a concern obviously for our customers, for yourselves, because the impact of that on local authority staffing would be difficult. So that's a little bit of a kind of whistle-stop tour. Conscious we've got about 5 minutes left for questions. If you have any questions, but also discussion points, I'd be really happy to engage in some chat around some of these areas.
Thank you, Alex. That was great. I was busily writing away, as I'm sure everyone else was. Just to remind everyone, we're going to send a link round to this full webinar if you wanted to go back on any points or share anything. just in the last 5 minutes, so Alex is here. If you have got any questions, please do put them in the chat, the Q&A, I think just anywhere where you can write stuff. That would be great. I'm going to kick off, Alex, with a question that's in my mind at the moment, around children's homes and care provision, essentially. So what we are seeing amongst our local authority customers is where for years and years care provision has largely been in the private sector, so care homes were outsourced. There are more and more customers, so in order to mitigate the high cost risks, the lack of local placements, all of those things, are actually building new care provision or buying existing but bringing it back under local authority control. I just wondered if you had any thoughts about that approach, whether the world has changed, because there was a risk reason why I think a lot of those provisions were put out. But yeah, what your thoughts are on that kind of in-house versus outsourcing, and what authorities should be doing to manage the different risks around that.
Yeah, I mean, I really agree with all the points you've made there, Alex. It's a shift we're seeing. It's obviously come about from a number of different kind of pressure points. Some of the changes around the increasing need of placements that are suitable for children with complex needs. Some of the market forces challenges when you're working with an independent kind of market providing or setting was difficult. So some children's homes saying no to more complex children, working with more complex children, because they were able to, because the market was really kind of in their favour because of the number of children that were requiring children's homes, and the fear of some managing some of the risk with individual children and the impact on that in the homes was a challenge. And I saw that as an individual children's social worker trying to get children into individual homes where they were really not keen on taking on the risk of working with an individual child with particularly complex needs. And then the kind of resulting increase in dolls applications, unregistered provision, it's hit a kind of boiling point. And the move for local authorities to be moving towards in-house provision solves a lot of problems. It is a really supportive measure for children and their families. So as a kind of child first kind of approach and a kind of family first, it is a very good measure. Having children's homes local and within kind of closely linked with the social workers that are there, are their allocated social workers, and having access to local services is such a helpful support. But managing the risk of managing those homes is obviously ongoing. I think the sector and I think local authorities have learned so much though, because of the histories, I think because of some of the big claims, the kind of historic abuse that's taken place. And I think I would say that the local authority sector is much more prepared to be able to manage homes effectively. And Stephen had mentioned briefly about vetting processes. We understand a lot more about safer recruitment. We understand more about preventative measures, about what you do within homes to keep people safe, keep children safe. We also know a lot more around just supporting children having voice and being able to report and share their concerns at an earlier stage as well. So the possibilities for things happening in those settings being reduced. I think probably as a social worker speaking to it, I think it's a positive move. I think a mixture of local authority provision and independent provision is a good thing. I think it's good for children, good for families, good for local authorities to provide better support for families, and it gives local authorities more control and more ability to shape those services rather than be at the behest of kind of independent providers. So for me, I think it's a good move, but it obviously, as you mentioned, it comes with the risks. So
yeah. Thank you. Great answer. Really comprehensive. So we're out of time. This is a subject I think Stephen and Alex both said all they've been able to do today is a whistle-stop tour of all the areas that could be covered. I know that local government reorganisation and the impact on this area alone is probably worthy of a full webinar in itself. So thank you everyone for joining. As I say, the link will be emailed out to you afterwards. I would encourage you to, so Alex has put her contact details on here, and they will be in the email along with Stephen's. But Alex is here to support you as our customers, as risk and insurance leads, perhaps engaging with your safeguarding teams. So please do reach out if you want any advice, if you want any follow-ups. She'd be more than happy to work with you to improve risk in this area. Thank you. Comments coming in, Alex, saying how useful that was. So I think, as always, you probably get a lot of information, a lot to digest. So as I say, please do come back to us. So the next presentation we've got coming up in this series is going to be on escape of water, so it might actually be a different audience, but look out for invitations coming into your inbox around that. Enjoy the rest of your Friday and your bank holiday weekends as they come, and yeah, we will hopefully see you on another webinar or in person soon. Thank you very much, everyone.